We turn in these times to Byron Henry, Dallas-Fort Worth attorney and constitutional scholar. Byron, good afternoon.
Glad to be with you, Guy.
We know that 5 Ninth Circuit judges, all GOP appointed, came out and they've been saying, look, the 1952 statute is clear. U.S. Code 8 is clear. The president has ultimate authority on this. So are the courts, or at least a few judges, ignoring the law?
Well, I certainly think there was some questionable judging with respect to the first order, though there was some confusion about its scope. But with respect to the second order, there can be no doubt that the president is acting well within the bounds of his authority. And the problem we're seeing here is just the way that the branches interact with one another. In most cases, whether it's a Republican or a Democratic president, the courts give the ultimate deference, and that basically is if there's even an arguable way to sustain the president's actions in a case that deals with delegated powers like immigration or national security issues like dealing with terrorism, case after case after case has the Supreme Court and other courts saying the president gets the benefit of all close calls, anything rational that the president does, and only in the most extreme cases with irrational action that is blatantly outside his authority or unconstitutional will the court step in and take action. And President Trump is getting no deference from the judges so far that have heard these cases.
Well, let's quote from the ruling that came down out of Hawaii, and then, of course, there's been a subsequent one from Maryland as well. But they're talking about that this is a Muslim ban because Donald Trump, the candidate, intended it to be that way. And the quote is this: "There is nothing veiled about this press release. Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States." We remember that he said that in 2015, but isn't there some case law that prohibits the use of a candidate's words being held against him later on once they're elected?
Well, of course, there's two things working here, Guy. First is if he called for a Muslim ban and then enacted a Muslim ban and then tried to say in court this isn't really a Muslim ban, he might be in some trouble. The problem is that by saying he believes a Muslim ban would be good policy and he would seek to impose one as president, and then he becomes president and he does not, in fact, impose a Muslim ban. He, in fact, opposes a very limited temporary stay on a travel from certain countries while he develops a new process. And it applies across the board to 6 countries, which, by the way, were designated exporters of terrorism by President George W. Bush's administration and President Obama's administration. So I guess President Obama was also discriminating based on religion when he named these countries exporters of terrorism based on internal reports and national security reports and evidence.
Okay.
So the problem with this is he didn't enact the policy that he said he might try to enact as a candidate. He actually enacted a very fair, a very modest policy as president.
So they're viewing this almost completely through the prism of his words as a candidate. I want you to listen to a very quick soundbite here and tell me if he's hurting his case today.
Remember this, I wasn't thrilled. But the lawyers all said, oh, let's tailor it. This is a watered-down version of the first one. This is a watered-down version. And let me tell you something. I think we ought to go back to the first one and go all the way, which is what I wanted to do in the first one.
Go back to the first one and go all the way. It almost sounds like he's calling for the original Muslim ban when he was a candidate. Are his words, is he essentially shooting himself in the foot? If he was your client, would you be concerned?
Well, I always don't want my client speaking generally about policy, but he's the President of the United States. That's his job to speak about policy, so he's not a typical client. But the problem is this actually proves Donald Trump's case. First of all, he's talking about the first executive order, that he believes the first executive order is constitutional and he should have taken it all the way to the Supreme Court. But secondly, it's proving that the second order, by saying it's a watered-down version of the first order, it is basically a tacit admission based on the lawyer's advice that it is not the first order. It is different. It is not the same policy as the first order. So therefore, it's a different order, and the court should do this order separately as a separate law. It's like Congress going back and getting one law struck down and enacting another law,
okay,
a separate law, and then saying, well, we're just going to review the first law, even though you went back and you enacted a whole new law that's completely different and has different exceptions and different provisions in it, and that's incorrect. The court should be looking at only the second executive order in this case.
Very good, Byron. Thank you very much. I know there was some concern voiced earlier today that perhaps he hurt his case last night by being so frustrated and speaking so generally. We always appreciate your insights, sir. Take care.
My pleasure.
All right. Byron Henry, a constitutional scholar. We turn to 313 on WJR.